Many individuals and businesses rely on copyright, trademarks, patents, trade secrets, or other aspects of intellectual property law to protect their creations against misappropriation. If they can afford to engage in this lengthy and costly process, that is what artists and brands do when they feel their ideas or products are being copied without their permission. When it comes to cultural heritage, however, ensuring protection tends to be more complicated. Intellectual property laws are designed to protect an individual's creations for a limited time span, whereas cultural practices and expressions are developed collectively over many generations. So, what that's saying is if I came up with an idea as an individual, I can go through the process to protect my idea. But if it's an idea that's been passed down from generation to generation and generation, and it's difficult to prove without a doubt where it came from, it's harder to protect that by law, especially if it happens over time. Furthermore, intellectual property laws usually reflect the worldview that is dominant in society, which is rarely an indigenous viewpoint. In other words, the laws are already put in place by the group of people that are in power. So they don't always protect the group of people that doesn't have as much power. Here's an example. The Navajo Nation owns 86 Navajo trademark registrations in order to prevent non Navajo designers from implying a connection between their products and the Navajo Nation when none exists. In addition, some Navajo weavers register their designs with the U.S. Copyright Office. However, others refuse to do so for cultural reasons. From a Navajo perspective, registering these designs under United States intellectual property laws would mean staking an individual claim to something that has been handed down in a family or clan for generations. So that's another tricky part. If your culture values sharing their traditions within their culture, it can be hard for you to want to claim that as your intellectual property because it belongs to your whole culture. But the laws don't protect it in that way. So, this is where cultural appropriation and intellectual property and law and rules and who makes money from what really get tangled up. However, the fact that most intellectual property laws do not adequately protect Indigenous cultural expressions does not mean they automatically fall into the category of public domain, available for everyone and anyone to draw from. In other words, just because the laws don't specifically protect Indigenous culture doesn't mean that everyone has a right to use whatever parts of Indigenous culture they want to. Customary laws that are in effect in Indigenous communities dictate specific rights, responsibilities, and cultural obligations. These regulate what can and cannot be used, by whom, and under what circumstances. In other words, Indigenous communities have their own laws that tell you what can be used, how it can be used, and who can use it based on that cultural heritage and those collective beliefs. In other words, it is not that indigenous cultural heritage isn't protected at all. Rather, the problem is that many people are unaware of or choose to ignore these rules. Why then don't Indigenous people turn to nationally or internationally recognized laws and accords to avoid this problem? In some cases, they do, adapting legal provisions and relying on international declarations to protect their rights as best they can. However, in all too many cases, these instruments simply do not provide adequate protection, and sometimes they can be at odds with Indigenous laws and principles. Basically, even though there are some laws, they actually don't work for Indigenous cultures all the time. We'll pick up here next.